Mr. Flowers, who hires these technicians?
They are hired by the Adjutant General, but they become employees of the Defense Department under 32 U.S.C. 709.
So under what authority does the Adjutant General hire the technicians?
Federal law empowers us to hire technicians that are
So it's done through delegation.
Yes.
So they are federal employees.
They are federal employees, and let me try to explain why. Because of that, it makes the most practical sense to route these disputes through the Defense Department. So,
But isn't the complaint you have the style of the at least in the petition it says before the Federal Labor Relations Authority, U.S. Department of Defense, Ohio National Guard is the style.
that is how the case was captioned, but it was always treated as a suit against the State Guard, not as against the Department of Defense.
But I thought the Adjutant General was an intervener, respondent.
The Adjutant General intervened to defend the interest of the State National Guard, which was the initial party.
So this would make, your argument would make much more sense if we were talking about the State Highway Patrol. Could you explain exactly when a technician is a federal employee and for what purposes, and when a technician is a state employee?
So they are always a federal employee under 32 U.S.C. 709E, and we're not disputing that they have collective bargaining rights or that we are using these federal employees. The question here is whether we are ourselves a federal agency, because they can issue an order to us only if we are in fact an agency. That's what the statute says. And we are not a federal agency, even if we are an agent or a designee of the federal government, because being someone's agent does not turn you into the principal, it just means you're acting on behalf of the principal.